Hey guys, welcome to our second part on 1099-C, which is the cancellation of debt and potentially being taxed on that cancellation of debt. So my name is John Watts. I'm a consumer protection lawyer. And if you'll recall in our first video, which you should have a link to either right here in this video or in the description, we're talking about the 1099-C form and particularly focusing in on this item 6, identifiable event code, which there's about 7 of those. Most of these don't apply to us. Number 6 is more like a short sale in a foreclosure context, and that's very important in that context. But for a credit card, we're really looking at item 7, which is the code G. G would go right here in this identifiable event code. And the instructions say that when there's a policy of the creditor to discontinue collection and cancel the debt. So that raises the question, if I have a debt and the creditor cancels it or tells the government, here's 1099-C, they put box G in that item 6, have they canceled the debt just for tax purposes, or is it canceled in the sense that I no longer owe it? Well, this was a battle that was fought between this I guess it's Gugger, versus USAA Federal Savings Bank. And this is in the context of a motion to dismiss. This is toward the end of 2017 in the Southern District of California. So the lawsuit was filed against TransUnion and against this bank, but then the case was settled against TransUnion, so it's really just the bank. So let's see if we can kind of see what we're doing here. The plaintiff sued under the Fair Credit Reporting Act, and the basis is the bank issued a form to the plaintiff regarding his account's debt. They issued the plaintiff a form 1099-C with code G marked. So remember, 1099-C, identifiable event, and then G is when discontinuing collection activity and canceling the debt. So let's go back to the opinion. And so the plaintiff, the consumer, says, I believed I was legally released from any further obligation. But when he gets his credit report, guess what? That debt's still being reported. So he sends a written dispute, which is very smart, TransUnion. TransUnion forwards it to the bank, but the debt was not removed. So he sends a second written dispute. Again, it gets forwarded to the bank, USAA, but the debt remains. And so it's verified as accurate. So he sues, and as I mentioned, he reached a settlement with TransUnion. And so now the bank has said, throw the case out, dismiss the complaint. We don't need discovery where we're putting people under oath. Just look at the complaint itself. There's no way that the plaintiff, the consumer, can win. And the court says, I don't agree with that. But we want to see the reasoning here. So we've talked about this in other videos, the legal standards. It's basically, you take the complaint as true, but there's certain things that you don't have to accept as true. If it's just a conclusion or there's not really a factual basis to it. So now the judge is going to get into this deal about the Fair Credit Reporting Act. Because remember, the lawsuit is not over the issuance of a 1099. The lawsuit is saying, okay, creditor, you did issue a 1099-C, and you put item G in there. But what effect does that have on my credit report? Why are you still showing up on my credit report? So the FCRA, Fair Credit Reporting Act, is to ensure fair and accurate credit reporting, promote efficiency of the banking system, protect consumer privacy. So there are certain duties on furnishers. So furnishers are the entities that provide credit information to the consumer reporting agencies. So the consumer reporting agencies would be like TransUnion, we've already mentioned, Equifax, Experian, Innovis, SageStream. I mean, there's a bunch of them, but the big three, Equifax, Experian, TransUnion. And so with furnishers like this bank, they provide the information to the credit bureaus. Now, what's their obligation? Well, when the furnisher receives a notice of a dispute from a credit reporting agency, a CRA, telling that furnisher the consumer disputes, then we get into section 1681 S2B, says, here's what the furnisher has to do. First of all, do an investigation. Number two, review all the relevant information provided by that credit bureau. Then number three, report back the results of the investigation. Number four, if that investigation reveals that, hey, we provided some incomplete or inaccurate information, then we have to give that to the other credit bureaus. Even if, like in this example, it seems as if maybe only TransUnion was disputed. Let's just assume that's true. And if the furnisher, USAA, figured out, hey, wait a minute, we really messed this up, well, then they're supposed to go tell Equifax and Experian also. And then this is really the key thing here, this item E. If it's inaccurate or incomplete or cannot be verified after investigation, then there's three possibilities. Okay, so this is where the bank, the furnisher goes, you know what, we kind of messed this up. So number one, fix it. Number two, delete it. Or number three, permanently block the reporting of that information. Now, from a consumer standpoint, really number two and three are about the same thing. It comes off of my credit report. Okay. There's also some discussion under California law. We're not going to get into that. The judge kicked out the California law. And just so this will apply to everybody watching, we're just going to focus in on the Fair Credit Reporting Act. So this is key to understand sort of where the judge is coming from, where the parties are coming from. Although the consumer does not bring a claim challenging the interpretation of 1099-C, USAA moved to dismiss the consumer's claims premised on the assertion that the Form 1099-C did not discharge the consumer's debt. And the court pointed out they had oral argument, so the lawyers were there making, verbal arguments. And they said much time was spent debating whether Form 1099-C discharges the debt, so the court's going to first address that. So what in the world is this 1099-C? Now, we've looked at it in the previous video, but the judge will give us sort of, the court's take on this. So whether or not an actual discharge of indebtedness has occurred, discharge of indebtedness is deemed to have occurred for the sole purpose of reporting requirements. So that's in what's called the CFR. So kind of the regulations. And then USAA argues the plain language of the form does not alone extinguish the debt. And so they say, well, look at these code sections. You have to file 1099-C even when the debt's not canceled. And then the bank says, we've got two of these IRS information letters, which are just sort of explanatory letters, explaining the IRS does not view a Form 1099-C as an admission by the creditor as discharge the debt and can no longer pursue collection. So it sounds pretty good for the bank here. And then the bank says, and by the way, other courts have ruled the same way, that the mere filing of a Form 1099-C does not discharge the debt. So what does the consumer say? I mean, it sounds pretty terrible for the consumer. Consumer says, here's the problem for the bank. They admitted to discharging the debt by selecting code G on Form 1099-C. Remember, code G, a discharge of indebtedness because of a decision or defined policy of the creditor to discontinue collection activity and cancel the debt. So that's the argument. And then the bank says, well, look at this decision, FDIC versus Cashin from the Fourth Circuit. And that was a summary judgment, which is not the same thing as motion to dismiss. Summary judgment is after discovery. Motion to dismiss is before you get anybody swearing under oath. And the court said, the Fourth Circuit Court of Appeals said, 1099-C was not a means of accomplishing an actual discharge or debt, but instead a reporting obligation. And so the bank says, it doesn't matter whether that case discussed code G or not. That's unimportant. And then the bank also cited to this Capital One case, and that's from Wisconsin back in 2014. And the court granted a motion to dismiss as plaintiff's claim the Form 1099-C as evidence of debt cancellation. And here's the real reason I want you to see this. And this is true for this particular issue, the 1099-C, but I also want you to understand for a broader issue, a lot of times we want answers that are just ironclad. tell me, is this right or is it wrong? But a lot of times in the law, we just don't have that. Different courts will interpret things differently. You could just grab random Supreme Court decisions, U.S. Supreme Court decisions. Now, these are 9 people that are very smart. And, while some people will argue, if you're a liberal, you say the conservatives are not, authentic and not being intellectually honest. If you're a conservative, you tend to say the liberals aren't being intellectually honest. Let's just sort of put all that aside and say these are really smart people. They are concerned about their legacy. I think they are being intellectually honest. But you'll see decisions where it's 5-4. So 5 judges said, well, clearly such and such should happen. Then 4 of the judges go, you're absolutely wrong. My point is different judges have different interpretation. So here on this 1099-C, it says the court finds a split in authority as to the legal effect of issuing a Form 1099-C. So we got that cashing case. That's that Fourth Circuit case. It says summary judgment against debtor offering only the Form 1099-C as evidence. And then there's this Ware versus Bank of America, a summary judgment against debtor for presenting no legal authority supporting the theory 1099-C discharges debt. Here's something in Tennessee, holding a creditor's issuance of a 1099-C reflects a discharge of debt. So here we have some different views. Okay. Now, the judge says most of these cases are decided on summary judgment and after discovery, and none of them discuss Code G. Remember, Code G is this item number 7, the cancellation of debt. And so the plaintiff, the consumer, says, well, hey, I haven't had a chance to conduct any discovery. And there's a case here where it says denying defendant's motion to dismiss because of Form 1099-C, in addition to supporting evidence, could plausibly extinguish the debt. And so the judge says there's some authority that suggests a Form 1099-C may itself be prima facie, or in other words, like enough to get you started, evidence for cancellation of debt. So this is from Arizona. And then the judge says, well, let's look at the instruction. Now, this judge is looking at 2015. We've been looking at the 2020 instructions up here. Okay, so you definitely want to look at whatever year the 1099-C is issued. You want to find the instructions for that year. But we'll see that it's going to be pretty similar here. So it says Code G means decision or policy to discontinue collection. And then it says the instruction is discharge of indebtedness because of decision or defined policy to discontinue collection activity and cancel the debt. So same thing we're looking at. At the pleading stage, in other words, before discovery happens, the court's required to accept all material allegations and complaint as true. Thus, the court finds that the consumer's argument that Code G indicates a discharge of debt under the plain language of the 2015 Form 1099-C is plausible. That's the test. When you're doing a motion to dismiss, you don't say, well, is it more likely than not that the plaintiff will win? Well, if I was the jury, would the plaintiff win? That's not what a judge is to do. A judge is not to say, is it, a good bit more likely that the defendant will win than the plaintiff. All the judge is supposed to do is say, is this plausible? Which is a higher standard than just possible. But is it plausible? Could this happen? And here the court saying, yes, I think it could. So the court is unable to rely on cash-in. That's that Fourth Circuit case. Is this not on summary judgment? And the court said, well, let's notice in cash-in, they say there are special circumstances. In another case, this is the cash-in court, the Fourth Circuit court talking, where a properly authenticated Form 1099-C is introduced, along with other circumstantial evidence of the cancellation of debt. The 1099-C could be properly considered by the trier of fact, that could be either the judge or the jury, under the totality of the circumstances on the ultimate issue of whether the debt in question was in fact canceled. So, our judge in this 2017 case says, so it's possible the consumer can discover evidence indicating his debt was actually canceled. And the implication is you combine that with the 1099-C and the the G notice or G code on there, that would be very helpful. And then the court says, I'm not particularly impressed with the IRS information letters. They may be relevant in the future, but not the motion to dismiss. And the court says, well, look, I find that the consumer sufficiently stated a complaint, but I do wonder whether the consumer will prevail on a motion for summary judgment at trial. But that's not before the court right now. So the basis of the complaint is whether an investigation was conducted and if credit's being accurately reported. And the issue of whether debt's discharged is a part of that, but that's not the claim. So the motion's denied. And then the judge does point out this Fair Credit Reporting Act 1681 S2B. So that's the furnisher liability. When the furnisher, like here the bank, gets notice from the credit bureau the consumer disputes, then the furnisher has to investigate. So it gets a little confusing in here. USAA, TransUnion verified the information. Consumer provided little factual content to support the allegation. They willfully failed to review all the information. But here's the issue. It's kind of hard for the plaintiff, without getting somebody swearing under oath, to be able to say, let me explain all the facts that prove that they willfully ignored my investigation, willfully closed their eyes to the evidence. So the court says, look, the bank would be in the best position to engage in this factual inquiry because they would have the documents or lack thereof regarding any investigation. So again, we need discovery. And so that's the case. Now, we'll look at the follow-up, which is the summary judgment. And remember, all the times this judge has said, well, the plaintiff, the consumer, needs discovery. We've got to look at discovery. We're going to see that maybe that discovery did not occur. And that's going to be a huge problem for the consumer in the follow-up opinion in this case. So appreciate you watching this. If you're interested in this 1099-C issue, make sure that you check out our other videos in this series. And also let us know if you have any questions about this. Feel free to subscribe, and I'll talk to you guys later. Thanks a lot. Bye-bye.